In Hedley Byrne and Heller, 1964, their lordships outlined the Hedley Byrne principle and they explained and established the special relationship. After outlining the Hedley Byrne principle, their lordships applied it to the case in front of them. And when they applied this principle to the case in front of them, Hedley Byrne and Heller, they decided that the special relationship had not been established between the two parties. Therefore, Hedley Byrne's appeal was dismissed. Why? Hi, I'm Denise and you're watching Law with Denise. In this video, I will explain why their lordship said the special relationship had not been established between the two parties in this case. Firstly, if you're not familiar with the Hedley Byrne principle and you're not familiar with the special relationship, please watch this video. The link to it is also in the description. If you're familiar with the Hedley Byrne principle and the special relationship, you should be able to follow this video. So let's proceed. So in order to understand why their lordships made this decision, why they decided that no special relationship had been established between the two parties, I thought it would be good to look at Lord Pearce's judgment. Now, I'm looking at Lord Pearce's judgment, but I want you to bear in mind that all their lordships agreed that the appeal should be dismissed. And I want you to remember that they all had very similar reasonings for reaching their final decisions. But let's look at Lord Pearce's judgment to help us understand what was going on in the House of Lords with this case. Now, Lord Pearce looked at Woods and Martin Limited. He pointed out that in that case, there was a banker who was the defendant and a customer who was the claimant. And he said in that case, and with those types of facts, that type of relationship, it is generally accepted that a duty of care is owed by the defendant to the claimant. So specifically, he's saying that in situations which involve like a banker and a customer, yes, we don't need to do much thinking to determine if the banker owes the customer a duty of care. But he said, when we compare that type of situation in that case to Hedley Byrne and Heller, we see that it is different. Yes, Heller and Partners were a bank, but Hedley Byrne were not their customers. Now, if you're not familiar with the facts of Hedley Byrne and Heller, I would suggest you go and watch one of my videos. The links to those videos are in the description. So Lord Pearce says, no, looking at this case, the facts are different. We have in front of us a defendant who was a banker, but the claimant was not their customer. So in order to determine if a duty of care was owed, if there was any responsibility on the part of the defendant towards the claimant, we need to examine the facts of the case. We need to examine the transactions between the two parties. And when their lordships examined the transactions between the two parties, they all concluded that no special relationship had been established. And it is one thing that their lordships kept bringing up, which led them to decide that no special relationship had been established between the two parties. That one thing was the disclaimer that Heller and Partners put forward when they gave Hedley Byrne advice. And that disclaimer was without responsibility. The disclaimer that Heller and Partners put forward, their lordship said, meant that Heller and Partners had not voluntarily assumed responsibility towards Hedley Byrne. And if there was no voluntary assumption of responsibility by the defendant, then no special relationship could have ever been established between the two parties. Now, you may not be clear on what voluntary assumption of responsibility means. If you're not clear, I have a video in which I explain this in more detail, and the link to that video is in the description. So, no voluntary assumption of responsibility was taken on the part of the defendant because of the disclaimer they put in place. Therefore, no special relationship had ever been established. And if we re-examine what the special relationship actually means, we can see that it wouldn't have really made sense for their lordships to conclude that a special relationship had been established. Remember, the special relationship means or requires that the claimant was trusting the defendant to exercise a certain degree of care when providing them with information or advice, and that it was reasonable for them to trust that this certain degree of care was being exercised towards them. But if a disclaimer had been put in place which says without responsibility, was it really reasonable for Hedley Byrne to have trusted and expected a high level or degree of care to have been exercised when the information was being passed? Perhaps not. So in the end, their lordship said no, there was enough in that disclaimer to suggest to Hedley Byrne that there was no assumption of responsibility. So no, appeal dismissed. I hope that was useful. Until next time, thanks for watching, and please remember, like, share, and subscribe.